Welcome to today's program titled A Special Multi-Part Series, Guidance on State and Local Paid Sick Leave Laws, Part 12, Major Changes in California, Minnesota, Illinois, and Chicago lead us into 2024. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down, as it will not be reread, and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP, for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Josh Seidman. Josh, please go ahead.
Thank you, Kate. Hi, everyone. Good afternoon. Thank you so much for joining us today. It's part 12 of our paid sick leave webinar series. Joining me for today's presentation are my wonderful colleagues, good friends, Chelsea Mesa, Sarah Fowler, and Renata Walker, all of whom are core members of our Seyfarth paid leave specialty team. Next slide, please. Now, we have a really robust agenda to go over with you all today. Several major developments in states across the country. We'll start you off with a nationwide paid sick leave, paid time off law overview. We'll then pivot to a nice detailed discussion on the new statewide Illinois PTO law that goes into effect in just a couple of weeks. We'll also discuss the latest on the first of its kind Chicago combo paid sick leave PTO law that was enacted last month, as well as updates on when those requirements will be going into effect, and then discussing details on both programs, the Illinois and Chicago programs. We'll then jump over to Minnesota to talk through the new Minnesota statewide paid sick leave law that begins at the beginning of 2024, just a couple of weeks, as well as local developments in multiple municipalities in Minnesota that have had local paid sick leave mandates on the books, so changes not only at the state level, but local levels as well there. We'll then jump out west to California to talk about the major amendments that California has put into place for its statewide paid sick leave program and how those updates impact not only the state paid sick leave mandate, but also the various local paid sick leave mandates that exist in municipalities across the state. And then finally, we will wrap up today's discussion with a brief paid sick leave PTO law outlook as we head into 2024. What can we expect from this area, this subject matter, heading into the new year? And we'll have hopefully a few minutes at the end for questions as well. Next slide, please. So to get us started, and as we do with each of our paid sick leave webinar presentations, we're going to get us started with the state of things nationwide in the paid sick leave world. So let's go to the next slide, and we will see a graph that should hopefully look familiar to folks who have joined us for any of the first 11 segments of this webinar series. There are a number of states and localities across the country that have paid sick leave or paid time off mandates currently on the books. You can see that as of December 1st, 2023, there are 58 total of these mandates in the United States. Now, this number continues to move and shift and ebb and flow, and the reason being is that there are locations that have a number of these laws that come and go sort of on a temporary basis. Certainly, over the last going on almost 4 years now, there have been a number of changes with respect to temporary COVID-19 paid leave laws that are virtually all extinguished at this point. There's a few stragglers, but the overwhelming majority of those COVID-specific laws have come and gone. But we still have, if you add up the numbers in the federal column, the state column, and the local column, those three rightmost columns on this slide, those add up to 46 total laws. The reason that we have 58 listed as the total mandates on that leftmost column is because a number of these locations have multiple of paid sick leave PTO mandates currently on the books. And that is what makes paid sick leave administration and compliance as much fun as it's always been. And certainly the reason why I think a lot of folks are here today is given the moving pieces of this landscape. So let's take a quick deeper dive. At the federal level, we have still on the books Executive Order 13706, providing paid sick leave for many employees of certain federal contractors and subcontractors. Really important that if you do have contracts or subcontracts, to take a peek, make sure you know whether they are covered or not by this executive order. At the state level, you can see that that column kind of split into two sub-columns with our paid sick leave mandates on the one side, with California and Minnesota being bolded there. Those are two of the biggest, most recent developments. Again, Minnesota with its new program, California with its amendments. And then you see the PTO column, that in a few weeks, Illinois will formally be joining Maine and Nevada as the only states with a mandatory PTO law on the books at the statewide level. So we'll be focusing on those three states for today's presentation. Now, of the states that are on this grid, a number of them have more than one particular mandate, right? Colorado comes to mind. Colorado has both a paid sick leave law and a separate public health emergency leave paid leave mandate. New York State, as of this moment, has three mandates in this paid sick leave space: a general sick law, a COVID vaccine paid leave law that sunsets in a few weeks, and then a still general COVID emergency paid sick leave mandate that is still going to be on the books heading into 2024. So that's how we get some of these numbers that sort of expand the total count to the 58 at the state level. And then similarly, at the municipal level, you can see the locations, more than 24 that have at least one type of mandate. But again, multiple of these locations, Chicago being one of them, San Francisco another, LA another, have more than one of these type of mandates that are currently on the books. So with that is our paid sick leave landscape. We're now going to dive into the first major topic for today's discussion. I'm going to pass it to Sarah to walk us through the big changes coming in both Illinois and Chicago.
Thank you, Josh. Well, welcome to the wild, wild Midwest. If you've been following Illinois paid leave and sick leave this year, you know it's been a busy year out here. So today we're going to provide an overview of what's passed in Illinois, what's passed in Chicago. We'll give a little brief mention to Cook County, talk about our pipeline for 2024. Before we dive in, I did want to preface this by saying that, like many new laws of this kind, there remain a lot of areas of ambiguity here in what we're going to talk about. We'll note some of the areas where we have draft rules that we're referencing, we have draft regulations that we're referencing. These are not finalized yet. So we're going based off of what we know and can see right now, but unfortunately, even with Illinois state law going into effect in just a few weeks, we still don't have finalized guidance for that yet. So some of this advice may shift and change. Josh, Chelsea, Renata, and I have all been following these laws and working with clients on compliance, so they may jump in as well at certain points because we all have a lot of different perspectives to share on this. So let's advance the slide and kind of dive in, starting off with our statewide leave law. So you may be familiar with the basic contours of this law because it did pass early on in 2023. We've been living with it for much of the year, but Josh said it does go into effect on January 1. Covers virtually all employees, covers virtually all employers. It doesn't matter if you only have a few employees in Illinois, it will still be covered. Brief note on the effective date. So the act goes into effect on January 1st. That's when employees need to begin accruing Illinois paid leave. It does have a waiting period of when employees must be able to begin using that time. It's 90 days after the effective date of the law. So you can certainly allow employees to begin using their Illinois PTO sooner, but you're not legally required to allow employees to use their Illinois paid leave until March 31st of 2024, which is 90 days after the effective date. The law requires that employees be able to earn and use 40 hours of paid leave per year for any reason, and the text of the law says at their discretion. That means we can have a 40-hour annual accrual and use cap if we desire. The accrual rate is 1 hour per 40 hours worked. You can, of course, be more generous than that if you're trying to comply with other state and municipal accrual schedules. Front loading is permitted. It will avoid carryover requirements. If you don't front load, the law says, and certainly implied as drafted, that all unused time would carry over. However, the draft regulations that the Illinois Department of Labor has published say that employers can limit carryover to 80 hours. We will see if that makes it into the final draft regulations, which would be a helpful carryover cap for many employers. And just a note about those draft regulations, IDAL has said that they will be finalized before the effective date of the ordinance, that March 31st date. They have been published. They're subject to a comment period. We're not expecting them to be finalized by the end of this year. And employers, as it notes here, can set reasonable minimum increments of use of 2 hours. We can go to the next slide. Reasons for leave, sky's the limit. Any reason for leave, it's important to note that we can't ask employees the reason that they're using Illinois paid leave. We can't ask them for documentation to support why they were using the leave. So that might require some training of management, a shift in how we've been thinking about things as we go forward. The rate of pay is defined as the hourly rate of pay. It must be at least minimum wage. And the law says that this wage shall be treated as the employee's regular rate of pay. The draft regulations give a little more guidance on this, and they define regular rate of pay for those who are not paid with gratuities and commissions as the employee's average hourly rate of pay calculated in accordance with the Illinois minimum wage law. So the upshot is, for the state law, you shouldn't need to be changing anything with your regular rate of pay because that's going to follow the Illinois minimum wage law. Waiting period for use, as I briefly noted, 90 days after hire or 90 days after the effective date of the ordinance, whichever is later. You can, of course, be more generous and allow employees to use this time sooner if you would like. And employee notice. Employers can implement what they say are reasonable notice requirements, which they say are 7 days for foreseeable use of time off, as soon as practicable for unforeseeable time off. Now, of course, if you want to be enforcing a notice requirement like this and you can't be asking employees why they are using the Illinois PTO and you can't be asking for documentation, how we are supposed to have a meaningful advance notice requirement is something that I think is still something that is subject to debate, but still think it's helpful to put in a policy and try to encourage employees to provide that advance notice. But whether that has any teeth to it, that we can do something if an employee doesn't provide that advance notice, I think is a challenging aspect of this law. If we do want to require employees to provide advance notice of the use for leave, we need to have that in a written policy. Next slide, please. Separation from employment. This has been another interesting aspect of this law. The Illinois Paid Leave for All Workers Act does not require payment of paid leave at separation. The statute makes that very clear, and we include the direct quote from the statute here on the slide. It does say, however, if you're using other forms of paid leave, an existing paid leave policy like vacation or PTO, the traditional Illinois laws apply, which would require payout at separation. So if you have an existing vacation policy that already provides 40 or more hours of paid leave, and you're using that to say we're in compliance with the Illinois paid leave law, and we will touch on that pre-existing policy aspect shortly, the general understanding is that you would be keeping the status quo and continue paying that time out at separation. But certainly there are a lot of ambiguities around this given the no payout language in the statute itself. It also says that unused paid leave will be reinstated to employees who are rehired within 12 months. The statute itself doesn't reconcile this with if an employer does pay out the unused paid leave at separation pursuant to another policy. Hopefully there will be more guidance coming on this. There is a draft rule that references not needing to reinstate unused front-loaded PTO if it's been paid out at separation. somewhat unclear why the reference to it being front-loaded specifically, but hopefully we can get to a reasonable result where if an employer did pay out unused PTO to an employee, that there wouldn't be any further obligation to reinstate that upon rehire. We do have provisions related to collective bargaining agreements. We have an existing collective bargaining agreement as of 1/1/24. Not going to affect that, but we do need a waiver in any CBA after that if we're going to otherwise not comply with the requirements of the law. Record keeping and notice requirements, 3-year record retention requirement. There's a poster that has not been published yet that will be required. And we do want to include notice in any handbook or employee manual. The draft regulations say that if an employer chooses to impose terms and conditions on employees' use of paid leave time beyond the provisions explicitly required in the law, it has to adopt a reasonable written paid leave policy. That includes prior notification requirements that we just discussed. It includes grounds for denying use of PTO, which we'll touch on shortly. And the law does have, like so many others, an anti-retaliation provision specifically as well. Next slide, please. So on that note, the question that we get asked by many clients about this, can I ever deny someone the use of Illinois paid leave, especially with those ambiguous notice requirements, and I can't ask them the reason for leave, and I can't ask for documentation? Well, the FAQs that IDOL has put out and the draft regulations say yes, subject to certain parameters. They say it has to be in a written policy, and the denial is to meet core operational needs. And here is a list of the factors that IDOL has published, saying that they might consider in assessing whether the denial is based on operational needs. At one of the webinars that they presented recently, IDOL's director used a Christmas tree farmer example. So someone who has a very busy season this time of year obviously would have a hardship if people were calling off in great numbers during this time. So that might be a situation in which for operational needs, the employer could deny use of PTO. So for our other clients that have seasonal work, traditional blackout periods, we want to be transparent about that as much as we can in a written policy and explain that companies reserve the right to deny use of this paid leave for things like core operational needs or language to that effect. And we want to be training our managers on when it might be appropriate to deny Illinois PTO or having proper escalation procedures for deciding when to exercise that right. It certainly should be something that's used in more limited circumstances, and you'd want to be able to support why you were denying the leave in that situation. We can go to the next slide. Enforcement. We don't have a private right of action on the Illinois state law. It's going to be enforced by the Illinois Department of Labor, 3-year statute of limitations, and we noted here some of the potential damages and, of course, drawing attention to those penalties, which are per employee, so those can certainly drive up some of the damages that might be involved here. We can go to the next slide. Now we're going to move into Chicago paid leave and Chicago paid sick leave. So for many of you who have operations in Chicago, everyone's hair went on fire last month when Chicago passed this ordinance on November 9th. As Josh noted, it's a novel law requiring both paid sick leave and paid leave. And the kicker being that it had the effective date of December 31st, 2023. So the fun late breaking news is that the City Council does seem to have passed an ordinance to delay the start date of providing paid leave and paid sick leave to July 1st of 2024. That should give everyone some breathing room to be able to see what the interpretive guidance is and give more thoughtful approaches to how they're going to be complying with this law. So that's my holiday gift to all of our Chicago employers who are on the line to be able to share that news. We can take a breath now. But there are some additional changes that were part of this proposed amendment that we'll also touch on here as well. So in terms of coverage, again, like Illinois, it applies to virtually all employees. One of the provisions that really got folks riled up was this covered employee being defined as one who performs 2 hours of work in a 2-week period, because obviously you can have folks coming to Chicago for the tourism industry or for business conferences, and all of a sudden they're going to be a covered employee under Chicago's ordinance. The amendment that was passed changes that to 80 hours in a 120-day period, which is in line with what we've had for the Chicago Paid Sick Leave Ordinance. So while that's still, we should still consider when employees are on some extended work assignments in Chicago and what those obligations might be, that's hopefully a reprieve and better than the 2 hours of work in a 2-week period. Covers nearly all employers. There are some distinctions for small employers and medium employers, small being 50 and under, medium 51 to 100. And those are based on the number of covered employees as well. So those who may be very large in size but have smaller operations in Chicago should certainly look at those exceptions too. In terms of what our leave entitlement is here, we have 40-hour bucket of paid leave for a 12-month period. This is similar to the state law. It's leave that can be taken for any reason. We also have 40 hours of paid sick and safe leave for a 12-month period. And that's going to be the same reasons that we currently have in Chicago for the sick leave reasons, if you will. Next slide. Accrual and use. Because we have to make things fun and interesting in Chicago, we have a 1 hour per 35 hours worth accrual schedule in Chicago. So you may recall that Chicago existing sick leave is 1 hour per 40 hours worked. Illinois, 1 hour per 40 hours worked. Plenty of places outside of Illinois that are 1 hour per 30 hours worked, but we're going to go with 1 hour per 35 hours worked just to make it interesting. So, you know, we have to keep it exciting here somehow. So that applies to both paid leave and paid sick leave, up to 40 hours of each per year. There's also the possibility to front load. Now, the way that the ordinance was drafted, it said that if you front load paid leave, you didn't have to carry over. Our interpretation reading that was the conspicuous absence of discussing paid sick leave in avoiding carryover, and interpreted it reasonably to mean that front-loading sick leave would not obviate the need for carryover. But the draft rules that they've published may help resolve this, because they say, as we note up here, that unless the employer front loads in accordance with their other rule, which would be 40 hours, then the employer has to allow the employee to carry over 80 hours of sick leave. So hopefully this draft rule will go into effect and it can allow employers to front load the paid sick leave and not have to also allow for 80 hours of carryover, because that was an extremely high number of paid sick leave hours that would be potentially available, which is significant because, as it notes on the next bullet, there is no use limit for Chicago sick leave or paid leave. The carry hour standard, paid sick leave, again, 80 hours if we are accruing. Paid leave is 16 hours into the next calendar year. We also have different standards of increments of use depending on whether it's paid sick leave or paid leave, 2 hours for sick leave, 4 hours for paid leave. So again, as you know, that's a little different on the paid leave standard from the state of Illinois. We can go to the next slide. Rate of pay. This is an area that differs from most likely your current practice, as well as the compliance with the state law. It says that the rate of pay is the same rate regularly earned during hours worked. However, it also states that non-exempt employees will have a 90-day look back for their rate of pay, which doesn't include overtime or other premiums or commissions, but will look at their hours worked and their wages earned during that prior 90-day period to come up with their rate of pay. So this is a really significant one that we wanted to make sure clients are aware of now in terms of coding all of their systems and making sure that employees are going to be receiving their paid sick leave and paid leave at the appropriate rate of pay. Now that we have 6 more months to do that, hopefully that will be helpful to employers. The waiting period of use also differs between sick leave and paid leave. 30 days for paid sick leave. That's a big change from what Chicago's existing ordinance has been, which would allow a 180-day wait period. So we note here, consider your interns, for example. If you have summer interns, they're going to be allowed to accrue and use paid sick leave under this ordinance. Paid leave is 90 days after hire, which is like the Illinois law, so a little bit of a longer window for that. In terms of notice, the law says that employers can implement reasonable notice requirements for paid leave. They say that's 7 days, and you can include reasonable pre-approval processes from the employer to, again, maintain continuity of employer operations, similar to the exception in Illinois, and we'll talk about that again in a moment. Paid sick leave has a provision for 7 days for foreseeable absences as soon as practicable for unforeseeable. Next slide, please. Separation from employment also differs depending on the type. So like other paid sick leave laws, we don't have to pay out paid sick leave in Chicago, but for paid leave, we do. This is different from the state paid leave. It's in all likelihood the same as what you've been doing for any PTO or vacation policy in Chicago, but we do want to make clear that here the paid leave point provision has to be paid out at separation unless you fall into an exception for the medium employers, which have a delay of implementation. It's only 16 hours of payout for the first year that this is in effect, or for small employers who are exempt from paying out paid leave on separation. The law also has a very unique provision for unlimited PTO policies. So you can use a so-called unlimited policy for compliance with this ordinance, but you still have to pay out at separation, which is very different than what many of our clients are used to when they have these, what we often call routine or flexible time off policies. Because you have to pay out 40 hours of paid leave at separation minus any time off that the employee has taken in the prior 12-month period. The effect of that is, unless we just want to say we're going to be paying out 40 hours for anyone who's leaving, we have to be tracking when folks under these unlimited policies are using the time, so we know how much they should get paid out at when they're on separation minus those 40 hours. The collective bargaining agreement provisions, it doesn't affect CBAs that are currently in effect, but again, like the current sick leave law, we'll need a waiver for CBAs after that time. Record keeping and notice requirements, this has a 5-year record retention requirement. That's longer than the state requirement. Also has posting and annual paycheck requirements. The annual paycheck requirement may be familiar from the existing sick leave law. It also has balance notification requirements, and that's something that's different from the current Chicago sick leave law as well. You can provide that on a pay stub or some other system where employees can check and understand their paid leave and paid sick leave balance. And for written policy considerations, we do want to have a written policy for these Chicago's paid leave and paid sick leave requirements. It says employers need to provide written notice of the employee's paid time off policy, including any advance notification requirements. Next slide, please. For Chicago, can we deny time off with paid leave? Well, you'll see here that the draft rules do include similar conditions and factors that employers can consider in denying time off as part of that reasonable pre-approval to maintain continuity of operations. So factors like whether the employer is in a service for critical health or safety needs, whether it would significantly impact business operations. So our thought process for the state of Illinois can also be similar for Chicago here as well. Next slide, please. Enforcement, we have a 3-year statute of limitations, but here we have a private right of action. This will be enforced by Chicago's Business Affairs and Consumer Protection Division. A private right of action will begin immediately for paid sick leave, but there will be a delay of 1 year for the paid leave provision. There's also a new part of the amendment that is going into effect that would have I think they call it a cooling off period, that would require employees to wait a certain period of days before filing suit for their private right of action. The damages in Chicago are also steeper, you'll note, than the state. It's 3 times the full amount of leave lost. Cost attorney's fees, and those penalties are pretty steep as well, $1,000 to $3,000 per offense. Each day is considered a separate offense. So certainly something to be mindful of as we think about compliance. Next slide, please. Brief note about Cook County. Cook County is also considering an amendment that would substitute its earned leave law for earned paid leave. It would convert it very similar to the state paid leave law with 40 hours of paid leave in a 12-month period. It has a December 31st, 2023 effective date, but it has not been voted on yet. Cook County has a meeting tomorrow, and I believe this is on the agenda, so we're certainly keeping an eye out to see what Cook County may be doing as well. Certainly suspect that there will be changes to Cook County's sick leave law, given what we're seeing from the state and from Chicago. Another brief note about Cook County, if you are in an opt-out jurisdiction and not following Cook County's paid sick leave law, you need to follow the state Paid Leave for All Workers Act law. But unless and until this is amended, the Cook County paid sick leave will remain in effect for those jurisdictions that have not opted out. Next slide. So in terms of how we formulate a compliance strategy for the statewide level, Illinois does have a provision that many of our clients have found potentially attractive that says employers who provide already any type of paid leave policy that satisfies the minimum amount of leave, that 40 hours, are not required to modify the policies if it offers the employees the option to take leave at the employee's discretion for any reason. And we've seen some additional guidance come out from the state. The proposed regulations have a definition of a qualifying pre-existing paid time off policy that's different from the text of the law itself. Says it has to be in effect before January 1 of 2024, and it has to be one that in practice allows all employees to take at least 40 hours of paid leave for any reason of their choosing. So just it takes out that employee discretion language. Again, this is not a final regulation though, this is simply the draft. So again, something that we're monitoring. But the proposed regulations would say that if you have one of those qualifying pre-existing paid time off policies, you don't have to modify your existing policy, and the FAQs that IDAL has published support that as well. So the things that we think about when we're deciding, do we have an existing policy, will this work? We want to think about whether it covers all employees, because many times you might have exceptions for part-time employees, seasonal, temporary employees. You want to make sure that they're included in whatever your compliance strategy is. Does it check off the 40 hours? Does it allow the time to be used for any reason? And then we've been thinking up until these regulations came out, does it allow the time off to be used at the employee's discretion, which could impact some of the blackout dates or management approval requirements? It's again still a little ambiguous at this point in time as to whether it needs to be allowed at the employee's discretion, given some of the guidance that we're seeing coming out. Josh, I know you and I were talking about this right before our webinar. Anything else to add on that, the ambiguities here between the draft regs and the law itself?
Yeah, thanks, Sarah. I think you did a great job, and I'm glad we covered this one because we've had a few questions come in from folks today on this topic. It is, I think, certainly some ambiguity between the statute itself and these proposed regs. The big difference being this at the employee's discretion component, right, of the statute. The proposed regs are, as Sarah has said, still proposed. They're non-binding, and even if they are finalized as is, the law itself is still going to, carry a bit more oomph, right? But so I think providing the minimum amount that can be used for any reason, and to the extent the employer is able to within its sort of practices and administration of the policy, to build in the at the employee's discretion component, which obviously is a big deal. That it would, that is a worthwhile step given the wording of the statute. That said, these regs do give an employer sort of an escape route, right, that they can lean on if they don't sort of follow that at the employee's discretion component exactly to the most generous way it could be interpreted. So a lot of nuance there from just 4 words, but it is a big difference.
Yeah, and we can go to the next slide. Thanks, Josh. I did see a question come in about whether Chicago's eliminated the peculiar requirement about the FMLA qualifying leave and carryover. And so, yes, the new Chicago law does not have the FMLA restricted time carrying over provision. So that's hopefully a welcome change as well. Cook County, unless it changes, still has that requirement in place. So Chicago is different from the state of Illinois in that it doesn't have this sort of grandfathering in provision. It says that if you have an existing policy that grants paid leave or paid sick leave in an amount and a manner that meets or exceeds the requirements of the law, then you don't have to provide additional paid leave or paid sick leave. So for Chicago, we are going to need to make sure that we are hitting all of the requirements for compliance and not be able to rely on that pre-existing policy like we can in the state. And this is just a nice picture of our employee using his paid leave to go fishing, as I imagine may happen. We can go to the next slide. This I won't belabor very long because we've covered all the requirements, but hopefully for your slides and take home just a few of the key areas for compliance and noting some of the differences to make sure that we're being aware of, especially for our clients that are wrestling with having operations in the state and in Chicago, with the state going into effect soon, Chicago being delayed, a lot of trying to sort out what the best approach is here. So hopefully this is some help in wrestling with those different requirements. We can go to the next slide. Action items for compliance. Well, if you haven't already, you want to review your existing paid leave policies and determine what works, what doesn't work, where we might have to make some fixes. If you have employees that are in Chicago and employees outside of Chicago, we want to be thinking through what is our strategy for compliance going to be. Do we want a one-size-fits-all approach, even if that means being more generous to employees outside of Chicago? Do we want to be updating for Chicago now based on what has passed? Or do we want to wait till things are more finalized and set with the interpretive guidance and take a look at this as it gets closer to July 1st? Want to be making sure we're on top of the notice, posting, and balance notification requirements. If we need to be making changes to our system on the rate of pay issued for Chicago, like I noted, training our managers that they have a solid understanding, especially these new paid leave laws, so they're not asking questions and going beyond what they're entitled to ask of employees here, especially in terms of denying time off. And of course, monitoring for further administrative guidance and rulemaking, because again, as Josh noted, these are not final yet. And hopefully the guidance that's been put out is something that we can rely on and will come to fruition, but we will need to wait and see. So with that, I will turn it over to Renata to talk about Minnesota.
Thank you, Sarah. We can go ahead and flip to the next slide and dive into our content here. So there are 5 paid sick leave laws that will be in effect in Minnesota as of January 1st, with the most recent one, of course, being the new statewide paid sick leave law. Notably, there has been a kin care law in effect in Minnesota, but that's actually going to be repealed when the new statewide paid sick leave law goes into effect next month. Recently, the Bloomington and St. Paul local sick leave laws have been amended to align more closely with the Minnesota statewide law. And so we'll spend the next several minutes looking at the state of paid sick leave in Minnesota, first touching on the highlights of the statewide paid sick leave law, then reviewing some of the recent amendments in Bloomington and St. Paul, and then finally touching on some of the key differences between the statewide law and the local laws. So for the next several slides, we can walk quickly through the basics of the Minnesota statewide Earned Sick and Safe Time, or ESST law. This law goes into effect in just a couple of weeks on January 1st. Notably, the state has not released any regulations, at least not yet, but there are some FAQs on the website with some updates to the FAQs as recently as last week. And I will flag some of the interesting FAQs as we walk through the highlights of this law. At a high level, this law has very broad employer coverage and employee eligibility standards, so nearly all employees working in Minnesota will be covered. On the next slide, we'll get into some of the other topics, starting with accrual. So beginning January 1st, employees must accrue at least 1 hour of ESST for every 30 hours worked, up to a maximum of 48 hours of ESST per year, and 80 hours at any point in time. And there are a couple of interesting FAQs that touch on accrual. One states that if most of an employee's hours are worked in another state, the employer is not required to provide ESST under Minnesota law for those out-of-state hours. The employee only needs to accrue ESST at the 1 for 30 rate for hours that are worked in Minnesota. Another states that if an employer's accrual year starts prior to January 1st, 2024, the employer can count hours accrued prior to January 1st toward the 48-hour maximum annual accrual cap. The employee would continue to accrue ESST after the January 1 effective date, but the employer could still limit the accrual to 48 hours per accrual year. I do want to point out this is a non-binding FAQ. It's an interesting point that they have made there. There is no cap on carryover under this law, though effectively the carryover can be capped at 80 hours based on the law's 80-hour point-in-time accrual cap, and there does not appear to be a usage cap, and there's no usage waiting period. So employees can use all of their ESST immediately as it accrues. Moving to the next slide, there's some interesting front-loading options that they've put into place. So there are two options under this law that allow employers to forego year-end carryover. Option A is to front-load 48 hours at the beginning of each year and cash out the employee's unused ESST balance at year-end. Then option B is to front-load 80 hours at the beginning of each year. And there are a couple of interesting FAQs on the topic of front loading as well. So first, similar to the FAQ on accrual, there's also an FAQ that states that employers can count time that was front loaded prior to January 1st toward meeting their front loading obligations. Again, want to note that this is a non-binding FAQ, but an interesting concept. There's another FAQ that states that proration for new hires and part-time employees is not allowed. So employers must provide at least 1 hour of ESST for every 30 hours worked up to 48 hours of ESST per year, or front load at least 48 hours. In terms of increments of use, employees must be permitted to use their ESST in the smallest increment of time tracked by the employer's payroll system, not to exceed 4 hours. And that may sound similar to the standard that we've seen under the local laws in Minnesota, but it actually is a little bit more pro-employee, because the local law standards allowed employers to set an increment that was consistent with standards or payroll practices and industry standards or existing employer policies, which is not necessarily the very smallest increment that the employer's payroll system can track. And finally, ESST must be paid at the same hourly rate as the employee normally earns. The FAQs confirm that this is intended to be the rate that the employee would have earned for that particular shift if they had worked instead of using their ESST time. Moving on to the next slide, we'll look at some recent developments in the notice and posting space. So there is now a model notice available on the ESST website. This notice must be customized to describe the employer's accrual or front-loading system, define the employer's benefit year, and explain the employee's obligations with regard to providing appropriate notice to their employer when they have a need to use earned sick and safe time. This notice must be included in an employee handbook if the employer has an employee handbook. And again, this is not as simple as just copying and pasting it. There are fields that will have to be customized when you're putting this in an employee handbook. Now, the FAQs state that employers are not required to use the model notice, though, and they can actually use their own notice so long as they include all of the required information. There's also an update regarding balance notification requirements. Employers are required to print specific information on employees' pay stubs in Minnesota. Among other things, this includes the amount of ESST that the employee has accrued and available, and the amount of ESST used during the pay period. The FAQs confirm that this must be on the pay stub, and simply providing access to an online portal is not going to be enough here. Now that we've talked about the statewide law, we can move on to the next slide with some of the Bloomington ESST amendments. And I did say ESST, not ESSL. The city actually changed the name from Earned Sick and Safe Leave to Earned Sick and Safe Time as part of these amendments. These are just some highlights of the changes that are going into effect January 1st. These are not necessarily an all-inclusive list. So first of all, the 90-day usage waiting period has been removed. The reasons for use and covered family members have been amended to align generally with the state law. Notably, the state law specifically includes registered domestic partner, which the Bloomington law does not for covered family members. And as a result of the amendments, bereavement leave is no longer a covered reason for use under the Bloomington law. The amendments have also removed the unpaid leave option for small employers, so all ESST is now going to have to be paid leave. They have aligned the front-loading options with the state law in terms of how you can front load to eliminate year-end carryover requirements. And finally, employers are now required to reinstate, or not, I guess not now, but effective January 1st, required to reinstate an employee's earned sick and safe time balance if they are rehired within 180 days. And this was previously only required if the employee was rehired within 120 days. So another, more employee-friendly standard. Moving on to the next slide, we'll look at the St. Paul amendments very quickly. Many of these will look the same as what you saw on the Bloomington slide. And again, this is not an all-inclusive list, but it is worth noting that St. Paul has amended the increments of use and notice and documentation, as well as the notice and posting requirements to align with the state law. Moving to the last slide, we'll just take a quick look at some of the key differences between the Minnesota state law and the local laws that are in effect in Minnesota. And keep in mind that where there is a difference between state and local law, employers who are subject to both of those laws must apply the provision that is more favorable to the employee. So for the most part, Duluth tends to be the outlier on this list. There are a few key provisions in Minneapolis that are impacted as well. So starting out with employer coverage, the Duluth law applies only to employers with 5 or more employees, whereas the statewide law is a more generous coverage, 1 or more employees. Similarly, the employee coverage standards are more generous under the state law. For accrual rate, Duluth requires only 1 hour for every 50 hours worked. And Minneapolis actually allows employers with 5 or fewer employees to provide unpaid sick time, whereas, of course, the state law requires paid time, and it's 1 hour for every 30 hours worked. There are some differences in year-end carryover. The Duluth sick leave law allows employers to cap year-end carryover at 40 hours. Minnesota requires employers to allow 80 hours of carryover, as we discussed earlier. Balance reinstatement, there are some differences in the number of days that an employee who is rehired would have to have their balance reinstated. A couple of things with the reasons for use and family members, annual usage limits, waiting periods. Duluth and Minneapolis both allow a 90-day usage waiting period. That's not allowed under the Minnesota law. And then we've also discussed the balance notice and front-loading standards. So, again, if you're subject to both of the laws, state and local, you'll need to apply the provision that is most employee-friendly. So with that, I will turn the mic over to Chelsea to bring us up to speed on what has been going on in California.
Thank you. In California, we're so used to having so much to say. It's almost nice that I'm going to have to move quickly through just a few points I want to make on California today. So I'm enjoying not being the center of attention for once. I will spend just a couple minutes on California, and if we go to the next slide, I want to use it just as a moment of refresh on the Healthy Workers, Healthy Families Act of 2014, because that's where we're starting. All we're dealing with this year is some amendments to this. But as you may recall, we had a sick time law that went into effect, it feels like a million years ago, but it's almost a decade at this point, that does cover virtually all employees, although there is some CBA exceptions that are included in that law, not a CBA waiver, but a CBA exception. And the definitions are very, very broad. Employee just has to work 30 days per year in California to have coverage, and there can be a 90-day hold on the use of sick time. And the reasons for use are very broad, including sick, family care, and domestic violence as well. There's really not an ability to deny the right to use the accrued sick days. There's an anti-retaliation provision, much like all of the other sick time laws that we've been talking about. And California's law was interesting, and it had that rebuttable presumption that we were retaliating if we were taking action within 30 days of some use or protected activity by the employee under this law. And that's sort of where we started as a baseline, and we'll talk about the amounts and carryover and how that's changed in just a couple minutes. But on the next slide, I also wanted to touch on, in terms of current landscape, the local paid sick leave laws in California, which do tend to throw a lot of people if you have employees in one of the following 8 jurisdictions. California does have a law for you as well. And that's Emeryville, LA, San Diego, San Francisco, Berkeley, Oakland, Santa Monica, and West Hollywood, which has a PTO ordinance in effect. And all of these laws are a little different. They tend to be more generous than the California law in general. And the rule was and remains that if the state law or local ordinance is more generous, the employee gets the better benefit of the two. So an employee in LA, for example, will get the better benefit of both LA and the state law. And that has become particularly impactful with the amendments that we're going to be talking about today, because one of the aspects of the local ordinances that used to be more generous at the local level is now more generous at a state level. And so that's going to have some impact on your folks who are already accruing more time in some of these local ordinances. So let's talk about the amendments on the next slide. Basically, what has happened, the governor signed the law into effect on October 4th, and it becomes effective, on January 1st, so just a couple weeks away. So you still have a little bit of time to get your changes in place. It basically increases the amount of paid sick leave that an employee would have access to in a year. It used to be 3 days or 24 hours, which was what you could limit a California employee outside one of the local jurisdictions to annually, 3 days or 24 hours, whichever is larger. And now it is 5 days or 40 hours, which, if you think about it, California, even though it was one of the first to market unpaid sick, it wasn't anywhere close to being more generous. It actually was below average when you compared it to a lot of the other laws that went into place. So now it is essentially catching up to a lot of what the other state laws have, which is that 40 hours per year. But again, it's 5 days or 40 hours construed as whichever is larger. And this would impact both the annual use cap, if you're putting one in place, as well as if you are front loading. So if you are providing a front load of 40 hours per year, for example, it does get rid of your carryover and accrual requirements. It can be use or lose outside of those local jurisdictions. And if you are accruing, you are allowed to cap annual use at 40 hours or 5 days, whichever is larger. We don't have any guidance right now. So in terms of, and we're getting a lot of questions, can I just add 16 hours if I did 24 hours, mid-year at some point during the year, or can I do some sort of partial grant? We don't have a lot of guidance right now, so we're not really recommending doing anything like that. We know what the law says. We know it has to be 40 hours a year, and so anything short of that is going to be a little risky. So on the next slide, talk about the other ways this is going to be impactful. The point-in-time cap, as you may recall in California, if you were accruing at 1 hour for every 30 hours worked. That has not changed. The accrual rate has stayed the same, but what has changed is we used to be able to cap the point-in-time accrual cap at 6 days or 48 hours. Now it is 10 days or 80 hours. You still have the ability to cap your annual use at 40 hours per year, as I mentioned, but the accrual cap, the point-in-time cap, is now moving from 48 up to 80. And that actually also means that jurisdictions like San Francisco, Oakland, Emeryville, essentially all of them, if they were accruing, they need to move from largely 72 in many of those jurisdictions up to 80. We do get the question a lot about Los Angeles. You can grant in Los Angeles, you can grant 48 as long as you're carrying over up to 72, but because that's a grant, we at this point, absent additional guidance, aren't really viewing that as something that also needs to go to 80 because it's a grant and not an accrual, and the 80-hour point in time is very specific to accrual. But I know this is causing a lot of questions and a lot of confusions. We do like to keep things interesting in California, so of course, if you've got questions about it, we encourage you to come and ask us. We know that the law had a CBA exemption. The CBA exemption that existed under the previous iteration of the law remains the same. The rules for the exemption are the same, but some of the protections under the law are now extended to employees, even if they are covered by a CBA. And it's things like being able to use the time for the reasons for use under the statute, the anti-retaliation provision under the statute, and the fact that an employee can't be required to go get themselves a replacement under the statute. So those things are going to apply even to your CBA covered employees, even if they meet the definition for who's exempt under the California law. I know I sped through that. I want to make sure that we've got time for the last few little bits, but most importantly, and what makes me the most popular person on this call, is I want to give you the CLE code, which is, for those of y'all who are writing this down, take your pens out right now. I'll give you a half second. is SS, as in Seyfarth Shaw, so SS 2023 seems fitting for our final paid sick leave presentation for 2023. It is SS 2023. And with that, I will kick it back to Josh to close out the rest of our presentation and take us home.
Awesome. Thank you, Chelsea. Next slide, please. So this slide is an outlook on what's to come in 2024. We've talked enough about Chicago, Illinois, Minnesota today, so not going to get into those in any more detail. You can see the bottom half of this slide talks about potential federal legislation. That seems highly unlikely in 2024. Federal paid family leave, on the other hand, might be making some noise next year, so keep that in your back pocket. State laws, lots of activity here. Of the ones that are listed in that second bullet point, Nebraska is the one to pay a lot of attention to, probably followed by Connecticut. Both are making strong pushes in Nebraska to add paid sick leave for a first time, Connecticut to enact significant amendments to its program. And then you can see some municipal potential updates there as well. Next slide, please. And for the next couple of slides, just going to show you some resources that we offer. Next slide, we have both our premium sick leave survey and our paid leave mailing list, both of which you can sign up for. The latter, the mailing list, and reach out to us for more information on the former, the survey, with that email address. Next slide, please. We also have this webinar series and our Take It or Leave It podcast. There's some great resources for those of you who are struggling with paid sick leave compliance, either within a single state or nationwide. And I sped through those because I do want to get to some questions for you all. So very quickly, there's been a number of good questions that have come through on Chicago and Illinois, as well as Minnesota and California. But to keep it Chicago and Illinois focused for just the next few minutes before we wrap up. So there's been a few folks that have asked the question, what happens in Chicago now that the effective date of this benefit, this new law, this PTO sick leave mandate has been kicked, right, is now being pushed to July 1st of 2024 instead of December 31st of this year. So at a very high level, the Chicago lay of the land at the start of 2024, it seems most likely, we feel confident, that the existing Chicago sick leave mandate will remain in place for the first half of 2024. Now, that also means, because of some sort of sneaky moves by the city of Chicago, keeping this new PTO sick leave combo mandate technically in effect on December 31st of this year, but the requirement's not starting until July 1st, that the PTO law at the statewide level does not kick in until does not kick in Chicago, right? Unless the Chicago ordinance is amended sometime in 2024. So that December 31st date is still important, even though the requirements don't actually begin until July 1st. So Illinois PTO does not look like it will be applying in Chicago. And what do you do in Chicago for the first 6 months of 2024? Apply the Chicago regular sick leave law that we've all come to know and love over the last several years. How's that? Did I get Sarah, Renata, anything to add on that?
The only thing I would add is that, if anyone wants to go above and beyond, it's, you got to hit the requirements of the paid sick leave law. But if we wanted to do more now rather than later, you could obviously, of course, do that too.
Yep. Great point. Cool. Here's another one that I thought was a good question. So this talks about a company that is offering PTO, right, for purposes of Chicago paid leave, right? So sort of combo, combo sick, vacation, personal in the single bucket. Wondering, right, how the PTO plan sort of might function with respect to, say, paying out balances upon separation of employment, when someone leaves the company. Now, so I'm going to, Sarah, maybe kick this one to you, and then I'll chime in after. But, if someone's using a single bucket of PTO for compliance with both parts of this new Chicago combo law, how would the payout upon separation work when this thing goes into effect for real in July?
I would be paying out all of it. Because if you're going to be using PTO for compliance with both pieces, that aligns with our more traditional Illinois view of paying out PTO at separation in general. It also, the paid leave component of Chicago's law says that paid leave needs to be paid out at separation. So that would be the best practice, I think, at this time.
Yeah, perfect. And there's been, I agree with all that, Sarah. Yeah. And there's been a bunch of questions about sort of the rate of pay for Illinois and Chicago. And admittedly, that topic is a really clunky, messy one here as well. I'll say that, just to sort of reiterate a point that Sarah made from earlier, it looks like Illinois right now will be sort of requiring for hourly non-exempts the regular rate of pay, right? We're still waiting for more guidance, more clarity from hopefully the final rules in Illinois. But that is, how the statute is reading, is that it's sort of that regular rate standard that's used for overtime purposes. Sort of similarly, Chicago, right, for its hourly non-exempt employees, talks about a weighted average, but that one is being measured over a 90-day look-back period, with certain types of compensation being excluded, as Sarah spoke about during the Chicago segment. So, if it gets to the point where companies are considering a one-size-fits-all program for the whole state of Illinois, that rate of pay, those differences between the state program and the Chicago program come July, are going to be really impactful if they're not reconciled between now and then. Any thoughts? Anyone else from the team on that last point? No.
Nope.
All right, great. So that is the top of the hour. So thank you, everyone, for joining us for today's webinar. Really appreciate your time. Feel free to reach out to any of us if you have more questions. We also had that general paid leave at SciFarth email as well from a couple of slides back. And we'll look forward to seeing you at part 13 of our webinar series in the new year. Happy holidays, everyone.